SJC-12192, Commonwealth v. Daquan Miller.
Good afternoon. We're not used to seeing you on that side.
It's a little unusual, Judge. I had to make sure I went to the right side when I walked up. Good afternoon. May it please the court. My name is Nick Brandt, and I represent the Commonwealth. What happened in this case was extraordinary. The trial judge here ordered disclosure of a confidential informant's identity upon quite literally no showing of materiality whatsoever. And that order was completely unmoored from 150 years of black letter case law in this Commonwealth, cementing, anchoring the privilege against disclosure absent that showing. And when the single justice was presented with that clearly erroneous error, she failed to act to correct it. And simply put, she didn't have the discretion to deny that petition when the petition presented an opportunity or request to vacate an illegal order.
If you can help me with some of the facts here.
Certainly.
I gather, from what I understand, that initially the Commonwealth said, we're not going to call the CI at any hearing or trial, and that's still the case, correct?
Always the case, correct.
And then apparently the defendant at that time said, okay, I'm not going to ask for his or her identity. And then the Commonwealth said, but wait, we want something more, and that changed it? What was the more?
I don't mean to interrupt. I don't want to go back to your first point. The statement was factually correct, but in the context of your second, I want to correct something. There was an agreement on the pretrial conference report between the parties that the Commonwealth said, if you, defendant, don't press your motion for disclosure, then I will limit my information about basis of knowledge and reliability at a motion to suppress to the information that I've already provided you with. The Commonwealth then subsequently, within I think a matter of a week or so, said there's actually additional information about basis of knowledge and reliability that the Commonwealth intends to present at a motion to suppress. And that's the context of this, if you want to call it the pretrial conference argument, that there was some sort of breach. With all due respect to my brother, I do think it's something of a red herring, only insofar as the judge ruled on that and decided that, notwithstanding whether or not there was a breach of the agreement, that the defendant hadn't shown any prejudice, and so that he wasn't ordering, he issued a written order saying he wasn't ordering any remedy for whatever happened with respect to the pretrial conference report. So what happens with respect to disclosure is really divorced and separate from that, and to attempt to, for a number of reasons that I can go into if the court wants, that's not really appropriate to logically think of whatever happened here with disclosure as some sort of remedy for the pretrial conference violation.
I got the sense, though, that it was linked. I don't know, interstitially. I just got the sense that somehow it was.
I don't see it, and I do know there's one page on my brother's brief where he suggests that in the disclosure order, the judge says something to the effect of, I ordered something earlier. When I went back and read that over the last few days, I think what he's talking about is the judge has this, I guess to some degree admirable, but misplaced notion that, well, if the Commonwealth's not going to disclose at trial, then why don't we just cut out the middleman in order, let's deal with the disclosure now. And I think that that's what the judge was referring to when he's talking about an earlier order.
Was this in anticipation of the motion to suppress, though?
Correct. The motion to suppress had been filed,
right.
But had not been argued and has still not been argued.
Right.
Correct.
So my memory, or understanding at least, was that the judge has to litigate a motion to suppress. We have an anonymous tip. Judge has to know whether or not this person has been reliable in the past.
Correct. The Aguilar-Spinelli basis of knowledge and reliability, and the Bocoin case, conceptually, it is a possibility for the Commonwealth to proceed at that kind of hearing without revealing the identity of the informant.
So what the Commonwealth wanted to do in this case was to say, here's what we have as far as basis of knowledge, and then the police officer could be cross-examined based on that.
Correct, and specifically, the cross-examination would have to be limited, though, to what the Commonwealth put forth at its peril. Of course, the Commonwealth could fail to satisfy its burden by not eliciting enough information. And going back to the Chief's point, the distinction was that what the Commonwealth had asserted they would elicit at the motion to suppress at the time of the pretrial conference report, then a week later or whatever, it was expanded. The prosecutor said, actually, I'm going to produce more information.
So the judge could say, you haven't met your burden to show that this person is reliable, therefore it's out.
It's suppressed, correct, and that would be apart and aside from any disclosure order.
That's why I'm wondering if they're linked. I mean, it's a motion to suppress. You don't have to give up the informant pre-Amaral and Franks. And it's pretty without that showing, it's pretty straightforward. So I'm thinking that the Commonwealth decides they're going to try and reach Aguilar Spinelli without the disclosure of the informant. Okay, that's your executive branch prerogative. It's going to be harder. Maybe you're going to do it. Maybe you're not.
Sure.
I find it hard to understand how the decision is not linked to the pretrial conference.
So I understand. I think what you're looking for, Justice Lowy, is sort of it goes back to why this is so extraordinary. There is no legal basis for this order, and the court, you're trying to look for one somewhere because you, understanding the law around confidential informants, know that what the Commonwealth was intending to do here was perfectly permissible and that there was no requirement for disclosure.
You may be arranging the deck chairs on the Titanic, right? Because what I want to get to is,
Sure.
Justice Link doesn't really get into the substantive part.
Sure.
The decision, as I read it, is more based upon the extraordinary remedy part of 211.3. That's where the issue is. So could you address that?
Sure, and I think that I know that the court issued an order when the case entered in this court, reminding the Commonwealth of where sort of the standard of review and its burden here. And I understand that the Commonwealth has to present the extraordinary circumstances before the court looks at the substantive merits. But I really, when I started reading this court's case law, those two inquiries are sort of inextricably intertwined when you have a order like this one that is fundamentally legally erroneous. That is the extraordinary circumstance.
But that's not our law, though. Our law isn't that we review every erroneous trial court ruling.
It's not everyone, but there are at least three cases
Or against the Commonwealth, I guess.
Sure. So there are at least three cases that I cite in section 1 of my brief in which this court has said that the single justice has no discretion to pass or to deny a petition that challenges a legally erroneous order. But putting that aside, and let's assume that we need legally erroneous plus something. So those things are here, right? And the first, the most powerful thrust, to use the Chief Justice's word, is the fact that a confidential informant is involved, right? So one, you have a privilege that goes back 150 years and that is longstanding, respected, and acknowledged by courts over and over again how important of a law enforcement fighting tool that privilege is. You also have that the disclosure puts somebody's life, potentially life, but certainly physical safety at risk, and that's sort of
It's the prosecution at risk, right? So that you can pull the plug, I guess, is what the bottom line is if we don't give you a release.
correct. That's true, but I don't think that's. I mean, the case law suggests that the privilege is to be respected absent this showing, right? So not only do you have that physical safety, you have the chilling effect. It's a chilling effect on this informant, and it's a chilling effect on whether other people are going to be willing to come forward in the future. But I also want to point out why this is extraordinary, is because if this disclosure is permitted to stand, then in what case is a disclosure order ever erroneous? This showing was literally nothing beyond a statement that, hey, there was a CI involved in this case. That person may, underline may, have been a percipient witness. I deserve their information.
Counsel, had this come through a motion to suppress,
Yes.
you would have had an appellate remedy, correct? If you had lost a motion to suppress because you didn't want to disclose an informant?
Sure, certainly.
You could have come through that.
Correct. We don't have.
So you didn't have that avenue.
Correct. And I don't mean to interrupt.
No,
cut you
no,
off.
that's just a point.
So it is, and it's kind of the unique, as I was thinking about this, the case is unique in that this is the only way the Commonwealth gets here to have this point discussed, is through a 211.3 and then, frankly, an adverse ruling by the single justice. There is no other way for the Commonwealth to appear and challenge an erroneous disclosure order of a point of, I've got to say, real serious importance.
Meaning that it's the extraordinary situation is the Commonwealth presented with either it has to publicize its CI and endanger that person or lose the case.
Correct, and
And
this is
that's
the.
essentially what you're presented with here. Either-
Correct. And we will only get review via this mechanism where we're sort of admittedly up against it in the sense that the Commonwealth has to show that the single justice abused their discretion, and that's a higher standard. But I'd say to this court, when you read the cases that I cite, this is the sort of universe where the court finds those circumstances. Jordan, I know I'm running low on time, but I really think Jordan, if the court's only going to read one case, I'm sure it will read more than that, is the one that's on all fours.
Can I go back to the chief's original question?
Of
though?
course.
So the chief says, okay, you guys were going forward with the motion to suppress, probably discovered you got thin gruel here based on what you've discovered so far. So then you try to substantiate this. Smart.
Sure.
I'm not saying it's not correct, but
Sure.
then that puts it in a little different posture, right? So that and I guess, does that give the single justice the ability to say, well, all right, the trial judge messed up the tipster rule, but I'm just not going to fix this?
So I don't think so for a couple reasons. One, the single justice, and I know the single justice is only obligated to write whatever he or she, I think, wants to write, but the single justice doesn't mention anything about the judge was considering this as a remedy, right? So how far you have, what weight you give that, I don't know, it probably deserves some weight too. But even so, even if we delve into, well, there was some bad faith or the Commonwealth did something improper, well, the agreement on the pretrial conference report was that the Commonwealth won't present any additional information, and in exchange, the defendant won't press the information, the motion for disclosure. That bargain was upheld insofar as the Commonwealth breached it by presenting or wanting to present extra evidence. The defendant was then afforded the opportunity to litigate his motion for disclosure. So insofar as there needed to be some remedy, the defendant got the benefit of what he had bargained for. So the idea that there's this other added penalty, which in effect is a penalty of ending the case, because the Commonwealth is faced with a choice of either putting someone into harm's way or pursuing a case, and 99 times out of 100, that's going to come out in favor of the safety of the individual. So I don't see how that, even if that was before the court, I'd suggest that would be an abuse of discretion.
One last question.
Yes, sir.
Perhaps the last question. Are you saying the Commonwealth versus Fort Lizzie was wrongly decided, or that your case is distinguished?
Not at all. Entirely distinguishable, because in Fort Lizzie, the witness in question is a witness who's going to be testifying at trial. So the information about whether that individual was had prior experience as a confidential informant goes directly to bias and all the kinds of things that we would talk about with any witness who was testifying, right? Here, completely different situation where this person is never going to testify at trial. And the Commonwealth would never call them at trial because the possessory offense occurs at the moment at which the defendant is arrested and has a gun in his waistband, and not when the confidential informant saw the defendant. All right, if the court has no other questions, thank you.
Mr. Schneiderman, good afternoon.
Good afternoon, Your Honors. Good afternoon. May it please the court. I am Joseph Schneiderman. With me is Laura Alfring, who is the young man's trial counsel. I'd like to open by responding to Justice Gaziano and to Justice Kafker. Justice Gaziano has correctly pointed out that the single justice's power under 211.3 is and always will
You
be.
talk a little softer, you're going to knock us off.
I'm sorry, Justice Kafker.
End of the day, so
I'm sorry. Is this better?
that's better.
Thank you. I'm surprised. I have a head cold. Justice Gaziano correctly articulated that the single justice's power is and always will be discretionary, and it only arises in circumstances which are truly extraordinary. It is not an error-correcting power, unlike the full court's power on FAR, for example. To respond a bit to something Justice Kafker asked, there are remedies short of the sort of binary nature that my brother has characterized things as. And to the extent my brother has characterized it as we have to go forward or we have to drop this case, that's not really so. The Commonwealth could seek remedies to limit disclosure, i.e., only disclosing to Attorney Alfring, having Judge Coyne examine the informant in chambers, or otherwise to have a protective order, and the record of this case is bereft of the Commonwealth actually exploring any of those options. Rather, the Commonwealth, after going back and forth in the trial court with Judge Coyne, went straight to the single justice session. And as this court has recognized, as Chief Justice Gantz articulated before my brother sat down, in Forlisi, these are the routine interlocutory disclosure rulings that do not warrant immediate relief under 211.3. To the extent the Commonwealth, and I share my brother's concern that people are not likely to come forward or that there will be problems, the Commonwealth bears the burden, though, of presenting an adequate record on that point in the single justice session, and they didn't.
Isn't this really just a run-of-the-mill informant situation? I don't see anything extraordinary whatsoever about this tipster and how this would be outside of what we see every day, or you see every day in every trial court on these types of searches.
I think, Your Honor, this is a unique scenario. I don't know that it rises to being extraordinary, but this is unique because the tip of the search was, the crux of the search was the tip. The tip came in.
That's every case. There's a guy down the street that has a gun, and they go down the street. There's, there's someone selling drugs on the street. That happens every day, doesn't it?
It happens often, Your Honor. I would agree with that. But the sum gestalt of all of this is that this motion to suppress, if it were litigated, would be dispositive of the case because the Commonwealth would have to show that the tip was reliable, and the time frame of all of this is very short. At Record Appendix 29 through 31, the police report, and again at Record Appendix 75, Detective Miller receives the tip. That's at 5 o'clock. At 5:33, the officers from the Youth Strike Force show up on Columbia Road and pat frisk Mr. Miller and find the gun.
That's Draper. That's every single Draper case. There's a guy with a limp walking on the bus and he's got drugs. So the trial judge's decision strikes me as out of the ordinary. That's for sure. The question is whether or not it's so out of the ordinary the single justice has to do something.
And I suggest that it was not so out of the ordinary because the judge's analysis is not an all or nothing. And that goes back to my point which I made earlier to Justice Kafker. The Bonet analysis, which governs considerations of an informant, is a totality of the circumstances analysis and requires consideration in the judge's sound discretion of whether or not to order disclosure. And Bonet is grounded in this court's decision in Amrell, which says, although disclosure is uncommon at a motion to suppress, disclosure is also not forbidden. And this correlates actually into why I think the Commonwealth has not shown extraordinary circumstances because, excuse me. I apologize.
No need.
I'm sorry, Mr. Chief Justice?
I said, no need to apologize, you've got a call. So.
This correlates into why this isn't an extraordinary circumstance because the Commonwealth has essentially treated their privilege as an absolute. Through the litigation in the trial court and in the litigation in the single justice session, the Commonwealth has treated their privilege as an absolute. It is not an absolute.
Did the judge below give the Commonwealth the protective order remedy and all that you propose now? Was that even an option by Judge Coyne?
The judge could have done all of that.
No, the question was, did the judge say, if you disclose, it could be subject to protective order, et cetera?
Judge Coyne did not say that, but Judge Coyne's memorandum, which is reproduced in the addendum and again in the appendix, says the young man at least deserves the opportunity to interview the informant. At that point, if there were concerns, the Commonwealth could have gone back to Judge Coyne and said, Judge, we'd like a protective order. Judge, only Attorney Alfring should be examining the informant. And indeed, Commonwealth...
So it was the investigator. Now you refresh my memory. Judge Coyne said the investigator should interview the informant.
That's correct, Your Honor, yes. And at one point, at Supplemental Record 152, Attorney Alfring even offers to say, disclose the informant only to me, I will interview him.
So if you had if it was a domestic violence case in the district court. And the girlfriend says, I want to assert my marital privilege. And the DA says, well, no, they can't do that. They have to be married. And the judge says, well, I don't think they really need to be married to assert the marital privilege. It's not fair. And the case goes to the single justice. Can the single justice say, well, this is not an extraordinary situation, so I'm going to deny it?
The Commonwealth would have shown, as I understand Your Honor's question, an error, that someone may not be within the ambit of the marital privilege. The trickier inquiry under 211.3 is whether or not that error is completely irremediable, and I would suggest actually, in Your Honor's hypothetical, the single justice may actually reserve and report that question to the full court, depending on the factual record there as to whether or not someone is indeed within the marital privilege, even if they do not have the magic grace of a marriage license.
And I did a lousy job with my scenario because I was trying to find one where it was clearly.
I'm sorry, Your Honor. To Your Honor's question, I think a clearly erroneous order, that is just not enough. The order not only has to be clearly erroneous, but there has to be something extraordinary about it, and the Commonwealth bears the burden of showing that record for the single justice to exercise their discretionary power of superintendence under 211.3. And indeed, as we've seen in this case, interrupting ongoing trials with 211.3 petitions are deleterious. This case remains stalled in the juvenile court at a potentially dispositive motion to suppress. The case has been on for status in the juvenile court, but the case has otherwise stayed. And that's part of why the Commonwealth bears the burden of showing that this is truly an extraordinary circumstance. And that is not just an error, but Justice Casiano?
No, they would, so your position is they would have been better off losing the motion to suppress than they could have come to us.
Absolutely, Your Honor. They could have litigated the motion to suppress. That would have been a remedy, as Justice Seifer suggested, and then they could have sought leave to take an interlocutory appeal, and then they would be here about that question.
But I thought the judge precluded. I thought the judge says you got to disclose first.
Yeah, I messed that up. Yeah, the disclosure would have happened before the motion to suppress.
Actually,
The judge didn't give them the option. They would have jumped at that option, I suspect. But the judge precluded that option by requiring them to disclose or to go down the road of disclosure. And isn't that's basically what Judge Coyne did is he completely turned around the tipster privilege and then the question is, what's the purpose of Rule 15 if it's not to fix those things? You know?
Actually, Your Honor, I think that is the purpose of Rule 15, which is if Judge Coyne got it wrong and the Commonwealth had proceeded through the motion to suppress, they could have sought and obtained leave to take an interlocutory appeal, and they could have said this disclosure was error. The Commonwealth has not shown why walking through that or indeed seeking a protective order or any of these other intermediate remedies are inadequate because, as I suggested before, the Commonwealth has essentially treated their privilege as an absolute, and it is not.
I'm
more
now
question.
totally perplexed because let's assume that you prevail here and the investigator interviews the CI, motion to suppress carries on. The Commonwealth's not going to call the CI. They present their evidence based on their view of the reliability of the CI. Maybe they win, maybe they lose, but I don't quite see if they lose what the relationship is of their loss to this issue because they didn't offer any evidence as to the CI. I don't quite see what their appeal would be if they were to lose. And of course, they might win, and then they have no appeal if they're going to win. They can't say, we now wish an appeal of the motion that we prevailed upon.
The Commonwealth's interlocutory appeal in this scenario would be that the judge erred in determining credibility. And that is what this case turns on, is the credibility of this informant. And the Commonwealth's interlocutory appeal would turn on that issue.
Do you think it would chill the ability of the police to cultivate informants and to take guns off the street if the Commonwealth says to their informant, thank you for the tip, we got a gun off the street, by the way, here's the defense attorney's investigator, you have to talk to him or her?
I'm sorry, Your Honor.
Don't you think that would chill the CI privilege and the police ability to cultivate information if the government would then say to their informants, go, here's Mr. or Ms. Defense Attorney Investigator, you have to submit to an interview?
I think there is a potential for chilling effect, but I think in the end, the Commonwealth has to show when they are in the single justice session that that possibility of a chilling effect is more than just, we are saying this because we are the Commonwealth. And I think if the Commonwealth did make that showing, that would be a different circumstance in this case.
But they did put it in the affidavit, and Judge Coyne, I think, found that there was gang involvement in this case, right?
I beg your pardon?
That there was gang involvement in this case.
Yes, Your Honor. Actually, that goes back, and I know my red light is flashing, but that goes back to the first prong, which is, I want to be clear about this. We are not contesting the adequacy of the Commonwealth's invocation of the privilege. There is a very real question that the young man and Mr. Norwood and others were gang involved, so the Commonwealth has properly invoked the privilege. The question is, on balance, in light of the Bonet factors, did Judge Coyne correctly decide to order disclosure? And in the end, he did. The Commonwealth would have to show that he and Justice Lank committed a clear error in judgment in weighing the relevant factors, and the Commonwealth cannot.
Okay, one last question, and I
course.
apologize because you'll give me a short answer, I know it. Why is this case different than Jordan?
In Jordan, disclosure was completely irrelevant to the asserted defense of self-defense. The defendant there, for lack of a better word, was on a fishing expedition because he found out about the defendant or the victim's status as an informant. That is the distinguishing factor from Jordan. I thank the court.
Thank you.
Court all rise.